Good morning, ladies and gentlemen. Welcome to episode 15 of our monthly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Once again, thank you for all your positive comments about these sessions, for continuing to sign up to them. We've got so many people signed up this morning, which is absolutely brilliant. So thank you for tuning in. Thank you for sending all your questions in prior to the sessions, and also for watching the videos online afterwards and listening to the podcasts. I've got a treat for you today. We've got three of our employment team who are going to answer three questions. Our speakers are up there in front of you: Keith Land, Ailsa Hobson and Catherine Hope. Catherine's going to go first, so without any further ado, I'm going to pass you straight over to Catherine. Catherine, good morning.
Good morning, thanks David, and good morning everyone. Thanks for joining us again today. I feel like I've been away for a bit with these, so it's good to be back. And I guess we're at what feels like quite a pivotal point with the end of the original job retention scheme and furlough leave coming to an end tomorrow, and the job support scheme, which Keith will be touching upon at the end. So it's an interesting time, certainly, when it comes to employment law. We've got a few questions and areas to cover today, and Ailsa and Keith will be following me. I'm going to start off by looking at one of the questions that came in earlier in the week, and it's to do with pile-on payments. Pile-ons, as many of you will know, it's where a payment is made to an employee in lieu of their notice entitlement when their employment comes to an end. And ordinarily you'll have a clause in a contract which entitles an employer to do that if they wish. Question came in. Now, ordinarily with this kind of clause, and it certainly brings up the importance of this, you would draft it in a way where it makes it very clear that any pile-on payment is restricted only to an employee's basic pay. So it doesn't include any of the benefits that employee would otherwise have been entitled to had they worked their notice period. Now, this particular question relates to a situation where there's a pile-on clause in a contract, but it's silent on what that pile-on actually includes. And the question is, in this situation, if we're terminating someone's employment and we're paying them a pile-on, so you're making them redundant or otherwise, are they entitled to the benefits they would otherwise have been entitled to during their notice period? Well, in this kind of situation, like many employment issues, you need to think about the statutory perspective and the contractual. Now, there's nothing from a statutory perspective that would affect this particular question, so it's going to come down to contractual interpretation. You need to look at what is in the employee's contract overall. The difficulty with this kind of situation, we can't give a definitive answer because from a case law perspective, there isn't a definitive case. What I would say, though, is it is arguable that a pile-on could be interpreted in such a way in a contract to say that it should include all the benefits that an employee would be entitled to. But again, it's going to come down to what's in that particular contract. Interestingly, there was a case going back to 2010 and that was the case of Locke versus Candy and Candy. And in that case, again, the pile-on clause was silent on what should be included. And the argument here was that the employee was claiming that their pile-on should include a guaranteed bonus that they would have been entitled to pay to had they worked their notice period. Now, the Court of Appeal in this case approached it on the basis of that a contract should be interpreted with an open mind. In this case, it was held that the employee was not entitled to that guaranteed bonus as part of their pile-on payment. And what was a deciding factor in this case was the bonus clause in the contract covering that guaranteed bonus made it very clear that the employee had to be employed at the point of payment. So that was a really important deciding factor, and that's why it is really going to come down to the drafting of the contract and how that might be interpreted, and that will be decided by the courts. So I would certainly look at your contract. It may well be there are certain things in there that make it very obvious and clear that certain or all benefits will be included. It might not be that there's anything at all. So it's going to come down to a decision. Look at your contract. It may well be you decide to actually just make the payment on a basic pay basis and wait and see if that complaint is raised. I guess in that situation, I would say again, the risk is going to be higher, and the risk of someone raising a complaint or that turning into a claim is obviously going to be higher if the financial amounts you're talking about are more significant. So if the benefits for a particular employee make up a substantial part of what they would normally take home on a monthly basis, that's obviously going to be more important than if you're talking about the difference of, say, a couple of days extra holiday that someone would have accrued. So it's going to come down to contractual interpretation on that one. That's a quick cover of that particular question. I'll now pass you on to Ailsa for comments and also covering the next topic. Thanks.
Thanks. Oh, thanks, Catherine. Good morning, everyone. Thanks, as Catherine said, for joining us. I'm picking up on a question that we may have covered, I suppose, along the way, or bits and pieces of it we may have covered. But ultimately, it's a question that's been cropping up more and more over recent weeks. So I thought it might be a useful one to cover. So that's kind of with clients and also sporadically through the questions we received from you as well. So it's to do with payment during isolation, and what I've done is I think it can be broken clearly down into 3 distinct categories, each of which attracts a slightly different benefit. So employees who are self-isolating because they have coronavirus or coronavirus symptoms, for example, high temperature, new continuous cough, or loss or change in sense of smell and taste. These employees qualify for SSP under the revised legislation, SSP legislation, and employees are actually deemed to be sick or incapacitated while suffering from coronavirus. And so they will also qualify for any contractual sick pay arrangements that you have set out in your employment contract, if that's something as you as employers offer. And I suppose remember that SSP can be claimed back from the government where you tick the relevant boxes. So that's scenario 1. You then have scenario 2, which is those who are self-isolating because they've come into contact with someone who has symptoms, or who've been told to self-isolate because someone in their household has symptoms. They've been advised to stay at home by their doctor because of an underlying health condition. That was more prevalent when shielding was around. It's not at the moment, but it could return, I suppose. They've been told to self-isolate by a doctor or NHS 111, or by test and trace, the government's test and trace service. So usually those employees will not necessarily be sick, but they have to stay at home because they've been told to do so. And under the revised legislation for SSP, they are entitled to that benefit. However, depending on what's set out in your contract of employment or your sickness absence policy, they're not technically sick or incapacitated, and so your contractual sick pay entitlements might actually not bite. So it's worth looking what the wording is under the contract. Normally you'd say if an employee is unable to attend work due to sickness or incapacity, then they're entitled to X number of weeks contractual sick pay in any rolling 52-week period. If that's the case, then they're not sick, they're just being told to stay at home. So they're not sick until they have symptoms or they have a positive test. And at that point, they're not entitled to the contractual element of their sick pay, only the SSP. So it's worth, I think it's a big distinction really, and it's worth bearing in mind if that's the baseline that you want to take. So the third category is employees who are self-isolated because they've been told to quarantine after returning from abroad from a country that's not in the travel corridor. I suppose this is probably one that keeps coming up time and time again because it has many different views. Yes, we all want to go on holiday and it would be great to go abroad, but are people putting themselves at unnecessary risk by attending countries not in the travel corridor, or even attending any country at all, given that the travel corridor keeps changing week by week, or at least it was in the summer months? So these employees under the revised SSP legislation don't actually qualify for SSP. So the government have taken quite a stringent line on it, saying that, I suppose, employees are putting themselves in a situation by going on holiday, so why should they be able to come home and expect to be paid for the privilege of having to quarantine for 2 months? And ultimately, because the government have made that choice, it's excluded from the SSP legislation, and as such it's also excluded from your sick pay clauses or policies that you have, because ultimately if SSP isn't due, then it's very unlikely that any contractual sick pay is going to be due, or that your contracts will deal with a situation where there's a forced quarantine, because that's not something any of us preempted happening. So in those instances you've got unpaid leave, or you can potentially consider extended holiday entitlement. But if someone's used 2 weeks of their annual leave, are they going to want to use another 2 weeks to quarantine when they get back? But ultimately that's the employee's choice. It's always better to have these policies in place prior to them going, but ultimately the best position is that you don't have to pay them for those 2 weeks if they're going to be returning. So my view is that the first and third point, so the isolation with symptoms and the quarantine, are pretty straightforward. If you're sick, you're entitled to sick pay. If you're quarantining after returning from holiday, sick pay is not really anything to factor in. The difficult scenario, in my view, is the second category, which is you have to isolate because you come into contact with someone. So in those instances, I suppose it's a balancing exercise. One, you want to make sure that the employees bring into your attention that they potentially come into contact with someone, or someone in their household has contracted symptoms or has a positive test, because you want them to be open and honest about that. Plus, if they're not and they come into work, they're potentially endangering the rest of your workforce, which not only potentially puts them in breach of contract on their own health and safety obligations, it also means that you have to enforce that, look at disciplinary, and it adds an extra layer, I suppose, of policy that you have to look at and plan for. And then against that, if you offer a more advantageous scheme, so the first one, I suppose, it puts people off if they think they're only going to get SSP. Some people can't only survive on SSP for a 2-week period, so that can put them off being honest. If, however, you take a more advantageous approach to it and offer full pay, you're leaving it open to abuse. So while, yes, people are only expected to get the virus once, they can be told to isolate through track and trace, whoever knows how many other times. We don't know how much contact they're having with other people. So that potentially is open to abuse and something that people could use time and time again, and they're very much more likely to do it if they are getting full pay. So it's trying to find a balancing exercise where you're, I suppose, getting your staff to be as open and honest with you as possible, but also not leaving policy open to abuse. Now, you can ask for evidence for people who are self-isolating. So, some of the evidence that's available is a note from the NHS 111. So if you're self-isolating, if you're told to, notification from NHS or public health authorities because you've come into contact with someone. Paperwork's generally issued then. A fit note is normal if you have one, or a GP letter telling them to stay at home. Again, that was more prevalent when it was shielding. So you can ask for evidence, but I'm not sure how long it takes to actually get these documents. So you're still potentially working with some risky days at the forefront of the weeks before that evidence can be given. And again, if you're paying full pay and the employee's not being wholly honest, and that happens time and time again, how much money are you actually losing? So one option, I think, to consider as a balancing exercise, and that's, I suppose, really comes down to if you offer contractual sick pay in the first place, or if in these circumstances you're prepared to offer it on a limited basis. So we're probably going to be looking at this over the next 12 months. So would you be able to offer a limited number of contractual sick days covering both isolation with symptoms and isolations due to contact? So you can say, under your contract at the moment, you get 2 weeks contractual sick pay. You might consider for the next rolling 52-week period, we'll up that to 4 weeks or 6 weeks. And once those weeks are exhausted, the employee's entitlement will drop to SSP. So that arguably closes the gap for abuse, because employers will want to save the entitlement for periods that they actually can't work, rather than using them all up and then having to face consequences when maybe they actually are sick. And it also doesn't prevent staff from being honest when they've been told to self-isolate, because it gives them that little bit more of a cushion to make sure that they're getting some form of payment. It's still going to be striking a balance, but I think that way you're recognising that people are going to be off for periods of time over the next 12 months because of issues linked with isolation, but you're not saying every period of isolation will be paid at full pay, which will potentially just be a, I'll have those, thank you. And obviously none of this is relevant at all if all of your staff can work from home. It's only really relevant if they have to come in, because through isolation, depending on how sick people are, you can work all the way through. Quarantine, you can work all the way through. But again, it comes down to the particular nature of the role that's been undertaken. So I suppose they're the three scenarios in a nutshell, and probably how I would deal with the most difficult of them. But ultimately, it comes down to a practice or a policy that you want to put in place. So that's it from me. I'll pass on to Keith. He might have some comments, but if not, he'll pick up on the JSS. Thank you.
Thanks, Ailsa. I didn't have any comments on what you were talking about, which was a very thorough analysis, as ever. I did have something in connection with Catherine's point, and apologies everyone if she covered this, but I'm currently working at home because I'm isolating in advance of some surgery, and my son is playing on the PlayStation and started massacring people on some game, and I had to zone out there for a minute to get him to turn the sound down. So if Catherine's covered it, apologies. Anyway, I suppose one point just to take into account in terms of what Catherine was saying on pile-on payments and whether you include benefits or not. What I would say is restrictive covenants. If you have restrictive covenants in your contract and you are looking to rely on those post-termination restrictions after the employee has left, you're better erring on the side of caution. If the pile-on is silent on the question of benefits, if you put a sum of equivalent to the value of those benefits into the pile-on, you're covering yourself, because if a court finds that the employee was entitled to the value of the benefits and they weren't paid, that would be a breach of contract. It would likely be a fundamental breach of contract, which will then go back and invalidate your post-termination restrictions. So consequently, if those things are important and the contract's silent on the issue of benefits as part of a pile-on, pay some more up front, you preserve your covenants. It's never going to be a massive sum of money unless there's some kind of colossal bonus, but there'll be some rules on that. So consequently, err on the side of caution, you preserve your restrictive covenants and you have an argument at the end of the day. OK, job support scheme. There wasn't particularly a specific question on this, but we took the view that I touched on it briefly last time. We had to cover it in a bit more detail now. Because we had the guidance that was published on the 22nd of October 2020. If you're looking for that, just do a Google search on the job support scheme. There is about an 18-page guidance as to what you can claim, what you can't claim, because obviously furlough finishes tomorrow, Saturday, and we have then the job support scheme, which is running thereafter, which runs through from the 1st November right the way through till the 30th of April 2021. What is out there at the moment from the government is not chapter and verse. The guidance, the 18-page guidance that's out there, which is on the www.gov.uk website, is a summary scheme. They say further guidance will be available at the end of October, and so in some respects that gives if you're working on business hours, that probably gives the government till 4 or 5 o'clock this afternoon. If it goes on the basis of at the end of October, they have Saturday as well. I imagine it'll probably be out at about 5 to midnight tomorrow or something like that, but we'll just have to see. It will be out when it's out and we'll have to react to that. So there will be more detail in that document from what I have said today. If you're going to avail yourself of the benefit of the scheme, you're going to have to get those documents, you're going to have to read them, and you're going to have to apply them. OK, there are two basic principles to the job support scheme, because the Chancellor has sort of amended it following political pressure. There is job support scheme open and job support scheme closed. Open being where you are able to open your business and continue to operate, but you are on reduced hours. And then you have job support scheme closed, where you are forced, given restrictions, to close your business entirely, or close part of your business entirely, I should say. OK, let's deal with job support scheme open first. OK, what have you got to do? An employee needs to work a minimum of 20% of their usual hours. And for those hours, employer pays them as normal. Alongside that, they will then have a number of hours that they are not working. The employer and the government will cover 66.66% of their wages, so 2/3 of their wages for hours not worked. That is subject to the employer covering 5% up to a maximum of £125 per month, and the government covering 61.67%. Up to a maximum of £1,541 approximately per month. So in a sense, it ensures that if an employee is not working, they get at least 70. If they are working short hours, sorry, they get at least 73% of their wages, up to where they earn up to £3,125 per month or less. Above that, a cap kicks in, and the employee's wages are more limited. OK, let's look at job support scheme closed. OK, this comes into effect where, as a result of coronavirus restrictions, and one or more of the 4 governments that all have different rules, forces you to shut your business or a set of business premises. Because if you operate a restaurant or a chain of restaurants, you might be operating in a city where you are open, and in another city you might be operating where you are closed. It ensures that people get 2/3 of their normal pay where you're forced to close and they're not working at all, up to a maximum of £2,083.33 per month. Okay, that's just the first page. I've got about 18 pages to go, so I'll have to go through it a bit of a canter. Okay, if you're in receipt of public funds, if your business is in receipt of public funds, you're not expected to use those public funds for people who you're I'll start that again. If people are in receipt of public funds, you're not meant to use this kind of scheme for employees who are paid by public funded grants. Okay. However, if the payment that you give to that individual is split across private income and public income, you can split the scheme accordingly. Who can you claim for? Well, employees. Only employees who are on the payroll between 6th of April 2019 and the 23rd of September 2020. Any type of contract, which includes 0 hours, temporary contracts. Agency workers are regarded as the agency workers of the people that's paying them for tax purposes, and so the agency. Employees don't have to be furloughed, and they don't have to avail themselves of the benefit they don't have to have previously been furloughed. You could have all your staff in, but if you're now impacted, you can avail yourself of the benefit of the job support scheme. Who can claim? Well, most businesses can claim. However, if you're an employee with 250 employees or more, this is for the job support scheme open, there is a financial impact test, which effectively says you've got to have an impact on your turnover to start claiming under the scheme. There's reams of about 3 pages of benefits, of explanations and advice notes in the government guidance, so I suggest you take a look at it. But anyone with employees of less than 250, you're automatically within the scheme if your turnover is impacted and you've got reduced work levels, or if you're forced to close. I said earlier that people have to work 20% of their working hours. If people have to do training and they are paid for training, that can contribute towards the 20% of their working hours. Okay, so they can come in and do a day's training in 1 week, and that would qualify them for the job support scheme open. What you have to do in terms of practical arrangements, well, you must have a written agreement. This was a bit of an opaque area with the furlough scheme. It's not with this scheme. You've got to have reached a written agreement with the employees to have them on shorter working hours, okay, for the job support scheme open. That agreement must be available for review by HMRC on request. The temporary working arrangements must cover at least 7 consecutive days. When you are picking who you place on short time working, you've got to have regard to all of the equality and discrimination laws, and so make sure you have some kind of objective method for selecting. You've got to maintain records, okay? You've got to maintain records to show that your selection of people was consistent with equality and discrimination laws. It would be sensible to have that in any event, in the event that a claim arises. You've got to have a written record of the agreement, and you've got to keep that for 5 years. You've got to have records of how many hours an employee has worked and what their normal hours would be, i.e. the ones that they're not working. And again, all of that information will be made available to HMRC on request. HMRC are going to produce further guidance on additional elements to include in written agreements by the end of October. Whether they do or not is up. Well, whether they hit that deadline at the end of October, we will just have to see, won't we? But it makes it very hard for you to sit down and negotiate your agreements with employees prior to this scheme coming into effect on the 1st of November if they haven't even got that additional guidance out yet. I think there's going to be a bit of running from behind and probably a bit of poetic license in what you can do in that respect. Okay. Job support scheme closed. I'll jump into that. Ailsa's not yet fallen asleep. I can see the top of David's head, and he looks like he's probably nodded off. Anyway, because it's riveting stuff. Nicholas hasn't shot anyone in 5 minutes, so that's all good. Anyway, but I should add, not shot anyone on Red Dead Redemption, which is a cowboy game on the PlayStation, not these running around with a firearm killing people. Okay, job support scheme closed. This applies where the premises have to close, okay, because of coronavirus restrictions, and therefore you can make a claim for. It's similar to the furlough scheme, to be perfectly honest with you. People go home, you get paid for them. It covers effectively 2/3 of their wages. This includes where your premises, if you're in the food or drink industry, is restricted to delivery or collection only. So if part of your business has had to shut down, but you're allowed to keep it open, okay, for other parts to provide takeaway services, and for people to come and collect food and drink, you can claim under the closed scheme for those employees that actually you don't need anymore, that you have to pack off home, such as your waiting staff, for example, or a section of your waiting staff, which is helpful. Okay, it applies again for those that are legally required to close. Minimum of 7. You've got to be required to close for a minimum of 7 consecutive days. Okay, again, that's not a complete list of the eligibility requirements. There will be more coming. So similar rules around keeping records as to the job support scheme open. So I'll not labour them again. For both schemes, okay, you cannot make a claim for. You cannot make somebody redundant, and you can't give them notice to make them redundant during a period where you are going to claim. There is guidance, and I say guidance in inverted commas, where they said if you're a large employer and you have 250 more employees, you won't make capital distributions such as dividends and things like that. However, that is not law. And what they're saying is they're leaning on, the government is leaning on people to do the right thing by the government. Whether you choose to do so is up to you. Taxes, okay, what's covered? Well, it won't cover national insurance contributions and pension contributions. They must be covered by the employer. Employers have got to deduct tax and national insurance contributions and cough it over to HMRC on what's paid to the employees. Employee then gets the net sum. Employers must pay any employers' NICs, unsurprisingly, on the sums paid. When can you claim? Well, you can claim from the 1st of October, but the first claims can't be made until around the 8th of December. So in effect, there is going to be a payment lag. You can put people on the schemes. You have to pay them in as per the terms of the job support scheme. So 5% or 2/3 of a percent, and you've got to pay them in a sense. You've got to cover the government's contribution for the month of November, and you then get reimbursed for it in December. So if you're going to use this scheme, you're going to have to dip into your savings or your reserves to make it work through the month of November before you get paid for your first claim, which is made on the 8th of December. So again, that might be awkward for some of you if you've not got cash reserves, but you're going to have to try and cover it. Fraudulent claims, HMRC can withhold if they feel it's a fraudulent claim. If HMRC decides afterwards that the overpayment wasn't, that there was a fraudulent claim, the overpayment will have to be paid back, and they can implement penalties of up to 100% of the amount overclaimed. So make sure you're doing everything right. They will also publish a naughty list, effectively, so they'll name and shame employers who are have abused the scheme. So not only will you get have to repay, there'll be a penalty. You'll get pilloried in the public domain as well. Interactions with other support schemes, you can claim the job retention bonus and things like that still. Calculations. Again, full guidance will be published by the end of October 2020. So we'll have to see on the calculations, but the reference periods for payment, okay, are a bit funny in that they are the greater of, if somebody has a fixed salary, they are the greater of the last pay period before the 23rd of September 2020, or the last pay period ending on or before the 19th of March 2020. So when the furlough scheme and those restrictions kicked off, okay? So it's the greater of those two sums. So where this has caused some issues for some clients is that they have in the last few months, tried to agree a reduction in working hours with their staff to keep them employed, in absence of making redundancies. And then the job support scheme comes along, and then they have to assess, okay, we can put employees on the job support scheme, open or closed, and then what do we have to pay them? Do we pay them on the basis of the money they received pre-furlough, or do we do it on the basis of their adjusted hours now that we've agreed to drop them, to have them working as from the 1st of November? The answer is, in effect, given the guidance that we can see, it would be the pay reference period back in March this year, because that's the greatest sum, and that has caused some issues with some of our clients who have then said, well, actually, we're now going to actually have to make further redundancies if we're going to rely on the job support scheme, because we were envisaging that we'll be paying people on the reduced hours, i.e. the ones that they've negotiated with people in, say, September, as opposed to the ones that they did work before the coronavirus hit us all. For employees that have variable pay, the reference salary is the greater of the same calendar period in the tax year 2019 to 2020, or the average wage payable in the tax year 1920, or the average wage payable from the 1st of February 2020 to the 23rd of September 2020. You can pick which is the greater, okay? When you've got employees that are working usual working hours or flexible working hours, the way you calculate it is you can pick the greater hours in those periods in exactly the same way. Again, have a look. What can you include? Well, it's regular payments, that's regular wages, non-discretionary overtime, non-discretionary fees, non-discretionary commission payments. Calculations can't include payments made at the discretion of the employer, like discretionary bonuses, discretionary commission payments, tips that aren't contractual, things like that. I think that's my generalised roundup. It was meant to take me 5 minutes. It took me more like 15 to 20. Again, have a look at the guidance. It's really clear. It's out there. It's a useful support. If there's anything you don't understand, David's just put our details up on the slide there. Please don't hesitate to give us a call. We'll gladly talk these things through with you. There will be further guidance coming out at some point in the next 24 hours, I would hope, which will put further requirements on employers. You have to have one eye on that, because I'd hate it that people weren't able to claim under the scheme because they've missed a technical requirement on what you have to have in the agreement with the employees, for example. Ailsa, I don't know if you have any comments. If not, I'll pass you, well, shout if you do.
I just had one, that was all. I think you were clear on it, but it was about the close scheme. You said, use the words forced and required to close, and I think that's obviously absolutely right. But I suppose it's if anyone were to leave that open to interpretation and think forced to because for financial reasons, so required or forced to just means that under the tier that you're situated in, you are told you have to close. If you take a decision to close based on financial reasons, then you wouldn't benefit from the close scheme. That was it. Yeah,
that's a really good point. Thanks very much. And actually, it leads me into one other point that I might have picked up along the way, because there was a lot to say. It's effectively those businesses that are required to close by local public health authorities, they're required to close. What it wouldn't cover, and I find this really hard, is if there are specific business premises. So it's the government generalised requirements. So tier 3, for example, would be one. However, business premises that are required to close by local public health authorities as a result of specific workplace outbreaks are not eligible for the JSS close scheme. I think what it's driving at in that sense is the government does not want people getting complacent about their generalised coronavirus safe working guidance, if you see what I mean. You've got to maintain your 2 meters distances. You can't just think, oh, whoopee-doo, if we're closed down, we'll be a bit gung-ho here, and if we're closed down, we can claim under the government scheme. So in a sense, yeah, you've got to maintain all of your current restrictions, all of your current working arrangements to ensure that you don't have a job or a workplace specific outbreak that causes your closure, because then you wouldn't be able to claim under these kind of schemes. There was another point, but it's gone out of my head. But anyway, it's in the guidance. If it's there, please look at it. Read the stuff. It's all out there. That's all I have to add. And so I'm going to pass you back to David, who will wrap up this morning's session.
Thanks very much, Keith. Very, very quickly from me, just a reminder on content, our useful and relevant articles, blogs, podcasts, videos, all of which you can find on our website, www.sintons.co.uk, and that includes all previous episodes of the Q&A sessions as well. Twitter, you can also follow the employment team on Twitter at SintonsHR. As Keith said, the team's details are there. If there's anything you want to raise further, please don't hesitate to get in touch with a member of the team. Our next session will be Friday, 27th of November at 10 a.m. And as usual, I will send the link round to you near the time. Thanks once again for so many of you signing up. We do really appreciate it. We are glad that these sessions continue to provide so much value to you. So from myself and the team, thank you very much for listening. Stay safe, have a good weekend, and we'll speak to you next month. Thank you.